Hi. So today I'm going to share with you about the types of evidence that is used in the court. Broadly, evidence is classified as oral and documentary evidence and direct and indirect evidence. In a simple language, oral means a person will come to the court and give evidence, speak whatever he knows about the crime or a situation or an event, either in the civil or the criminal cases, oral and documentary evidence, and direct and indirect evidence. Now, what is indirect? This becomes a direct evidence. Now, what is indirect evidence? Indirect evidence means circumstantial evidence is indirect evidence. So, today I'm going to share with you about hearsay evidence. Now, what is hearsay evidence? Hearsay evidence is a second-hand evidence, which is not permissible as per the Evidence Act. The witness who comes to the court in a civil or a criminal case must see the crime or must be a witness to the transaction, civil transaction, through his senses. Through his 5 senses, he has to be a witness to the transaction. Then only he can be called a witness. Otherwise, he is called a hearsay witness or a hearsay evidence, now which is not at all permissible in court. I'll give an example so that you can understand in a better way. A informs B that A saw X killing Y. Now, X is the accused in the criminal case. Y is the deceased. Now, A is a witness to the crime. A saw X killing Y. Now, A shared this information to B. So, A is the direct witness and B is the hearsay witness. Or B, if B comes to court and gives evidence, it will be hearsay evidence. Court will not allow this hearsay evidence, will not consider this hearsay evidence. So, now there is an exception. Today I am going to share that exception with you. The exception is that if C is a witness to A sharing the information pertaining to the crime to B, when C is a witness to the transaction between A and B, then the evidence of B is corroborated by C. Corroboration means giving strength, authenticating the statement of B. It is a simple case. I will summarize once again. X killed Y, which was seen by A. A is a direct evidence. A shared the information to B. B is the hearsay evidence. And C is a witness to A and B. So that's how hearsay evidence becomes a valuable piece of evidence in the court. So here what happened exactly is that the second-hand evidence, that is the hearsay evidence, is a second-hand evidence which was corroborated with the direct evidence from C. C is a witness to the transaction between A and B, and when A comes to court and speaks about the crime as a direct witness, C comes to the court. Here C is also a hearsay evidence. To some extent he is a hearsay evidence because C also did not see the crime. B also did not see the crime. But here C is a part direct, part hearsay. Hope you are getting the point. So C is a witness to the transaction between A and B. When C corroborates the statement of B, then the value of the hearsay evidence becomes important and shall be considered by the court. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.